Well, hey there, this is Seth from the RE Tipster blog, and in this video, I want to talk about a legislative issue that I've heard about quite a bit over the past few years, and it's called Dodd-Frank. And Dodd-Frank, perhaps you've heard of it, maybe not, but it was basically this big piece of legislation that was put in place back in 2010, and then it's been updated a little bit since then. And it basically contains a lot of different rules and regulations that make it much, much harder for the typical real estate investor to sell their properties with seller financing. And this is kind of a big deal because prior to Dodd-Frank, there were a lot of people who were selling houses and other types of properties with seller financing, and it was a big deal to their business. I mean, that was really how they found buyers who couldn't otherwise qualify for loans and ultimately make more money in their business because they could offer financing and collect interest and all this stuff. And when Dodd-Frank came out, it kind of dropped a bomb on a lot of that for a lot of real estate investors. And Dodd-Frank came about sort of in response to the big economic downturn that happened starting in 2008, 2009, and going on for several years after that. And ultimately, this was the government's attempt at putting more regulation on lenders and making them follow certain rules. What I want to talk about specifically is how Dodd-Frank applies to people who are trying to sell vacant land with seller financing. Because I remember when Dodd-Frank first happened, and it was something that I heard from a lot of the voices in the land investing space, was that you don't have to worry about it. Dodd-Frank doesn't apply to land investing. And I was really relieved by that, and I did a little bit of research on my own, and I saw mostly the same thing. But just recently, I was encouraged by somebody in the RE Tipster Club to just put a lot more clarity in this and just to really dive deeper and to get all the information. And that's sort of what I've been doing over the past week is like really, truly trying to actually read all the regulations and doing a deep dive on a lot of the research to find out how this does and doesn't apply to vacant land. And keep in mind, I am not an attorney, and this is all purely my non-legal opinion and summary of what I found when reading through it. It's entirely possible that I missed something. I mean, if you've ever read through these regulations, it's a ton of stuff. I mean, it's kind of ridiculous how many rules there are. So keep in mind, I may not be covering like every possible aspect of it, but just from what I found when reading through these regulations and also when sort of going through a summary put together by some other blog posts out there, which I'll link to in the blog post that goes with this video, there actually are some aspects of Dodd-Frank that do apply to vacant land transactions. It's not like vacant land is just totally exempt and we don't have to worry about it. There are some things, but the things that do apply, in my opinion, are not deal killers, and they're not hard to do, but it is stuff that you should be aware of if you're trying to sell vacant land with seller financing. It's not like you can just necessarily ignore this. I think you can ignore a lot of it, but it's not just something as simple where you can just throw the whole thing out and not think about it. And in this video, I want to just take you through my research and what I found so you can just see what I'm looking at. And when I do seller finance deals, these are the things that I believe do apply to me. And it's really up to you as to whether or not they apply to you or not, because it sort of varies depending on what kind of deal you're doing and how many deals you're doing. But in this video, I'm just going to take you through each of the regulations that seem to apply and which aspects of those regulations I think we need to pay attention to as land investors. So what I could see, there seems to be 5 big regulations that are sort of tied in with Dodd-Frank that seem to apply on some level to real estate investors in general and or land investors specifically. And I kind of got this from an article that was recommended to me by Carl James. He's a member of the RE Tipster Club. But he pointed this article out to me, and I thought it was really helpful just in kind of breaking down the things that are applicable to vacant land transactions specifically. And the regulations are Regulation Z, Regulation B, Regulation X, Regulation P, and Regulation N. And I'm just going to, as fast as I can without boring you to death, try to hit the most applicable parts of each one of those. So the first one, Regulation Z, the Truth in Lending Act, this is kind of like the big thing that most people associate with Dodd-Frank. And just so you understand some of the background, when Dodd-Frank was put in place, it created something called the Consumer Financial Protection Bureau. And this bureau was put in charge of creating and amending some of the existing regulations that had already been out there for decades. And these regulations that you hear, Regulation Z and Regulation B and all this stuff, these aren't necessarily new things, but the CFPB can basically go in there now and change it. And that was what happened shortly after Dodd-Frank came out, is they went in there and they added a lot of new requirements to some of the existing regulations that were out there for lenders. So the first one again is Regulation Z. And Regulation Z is most commonly associated with Dodd-Frank because it contains the biggest list of just stuff that lenders have to pay attention to when they're lending money. And I'll just sort of show you the things in Regulation Z that I thought were applicable and the things that I thought were not when it comes to vacant land transactions. Probably the biggest issue that most real estate lenders had with Regulation Z, if you scroll down here, and by the way, this is the actual text of the regulation, so this is like from a government website here. And if you go here to the section that says special rules for certain home mortgage transactions, if you click on this, you can really just read a lot of this stuff. It's incredibly boring, but if you drink a lot of coffee, you might be able to get through most of it. But some of the biggest issues that were inherent in this section is that it essentially requires some pretty restrictive things of people who want to sell real estate with seller financing. It says that first of all, if you do more than 3 real estate transactions per year with like a land contract or a deed of trust, you have to be a registered mortgage originator, which is a big obstacle that a lot of real estate investors don't necessarily want to mess with. It also says that you can't have a balloon payment sooner than 6 years. So, a lot of people who sell real estate with seller financing, the goal is to keep the loan out there for 3 years or 5 years and then have a balloon, which basically means the entire balance comes due. And the idea behind that means that the buyer then has to kind of cash out the seller and go find a conventional loan so that the seller can then get their money back without waiting for, decades to get their money back. But it's basically saying that, you can't do that faster than 6 years. So that's something that a lot of real estate investors might have an issue with. And then another huge issue is that the lender is basically required to verify the borrower's ability to repay the loan. And that can be kind of a complicated thing because it means the lender basically has to go through a similar process that a bank would go through to verify their income and just to make sure that they're a good credit-worthy borrower. And that's something that some people may want to do, but if you either don't want to do it or you just don't have the resources to do it, that little rule kind of gets in the way. And in some ways, it's saying that the only people you can lend to are those who can already get a bank loan anyway. So it kind of just takes out a huge pool of buyers, and it also makes it harder for borrowers who would want to get a loan and now they can't because they don't qualify. So it just kind of puts a lot of restrictions that, in my opinion, don't need to be there. But all that said, there's a very important thing to remember with all these requirements. All of these special rules have to do with certain home mortgage transactions. So let's keep that term in mind. And then let's go back up here to the definitions. Down here in section 24 it says, residential mortgage transaction means a transaction in which a mortgage, deed of trust, purchase money, security, interest, blah, 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 is created or retained in the consumer's principal dwelling to finance the acquisition or initial construction of that dwelling. So first of all, the consumer's principal dwelling. So that's like a place where they're actually living. And then that word dwelling, what does that really mean? If we go back up here, dwelling is defined as a residential structure that contains 1 to 4 units, whether or not that structure is attached to real property. The term includes an individual condominium unit, cooperative unit, mobile home, and trailer if it is used as a residence. So as I read that definition, that is not the same thing as vacant land. Vacant land seems to be excluded from all of these special rules listed out in subpart E. So that's my understanding as I read it, and I've talked to more than one attorney about this, and they seem to agree with me. And again, I'm not an attorney, and I'm not saying I'm right. I'm just saying that is how I read and interpret that, and I'm not alone in that conclusion. So you can kind of take that and do with that what you will. I don't know the specifics of whatever deal you're working on, and there can be some issues that come into play. For example, if somebody chooses to build on a piece of vacant land immediately after they buy it, then it sort of is considered a dwelling at that point. So that can change things, and for that reason, it may be smart to put something in your loan documentation to the effect of requiring that buyer to pay off the loan before they can start improving the property, because that would kind of ensure that for the life of the loan, it stays as a vacant lot and is not considered a dwelling at any point. So really, the most problematic list of issues right here is kind of dispelled by the fact that with vacant land, it's not a dwelling and it generally shouldn't apply. So that's good news for vacant land investors. However, something that I will point out is that when you go here to this first section of Regulation Z, it explains the coverage of what Regulation Z applies to. And it says, in general, this part applies to each individual or business that offers or extends credit when 4 conditions are met. And those 4 conditions are the credit is offered or extended to consumers. And there's actually a special definition for what that means. But for all intents and purposes, most of the people I sell my properties to are definitely considered consumers. And then the offering or extension of credit is done regularly. And the credit is subject to a finance charge or is payable by a written agreement in more than 4 installments. So that's definitely what my seller finance deals fall under. And the credit is primarily for personal, family, or household purposes. So a person plans to use that property, for those purposes and not for like a business purpose. So really, a lot of the deals that I do still fall under this definition and are covered by Regulation Z. It just isn't covered by this problematic section of Regulation Z. So what it is covered under is, from how I read it, it's considered an open-end credit. And open-end credit is like a catch-all for all kinds of different loans. This is not just real estate loans. I mean, this can be like credit cards or home equity loans and all that stuff. And according to subpart B here, there are actually some disclosures that lenders are supposed to provide to their borrowers. And I'll just be totally honest, I did not read this entire thing, so take what I say here with a grain or two of salt. But as I was sort of skimming through it and just getting an idea for what types of disclosures would be required of somebody like myself to disclose to my borrower when I'm selling them a piece of vacant land on land contract or with seller financing of some kind. And a lot of the stuff that people in my situation would be required to disclose to the borrower are things like what kinds of fees are associated, maybe like the interest rate, sending out periodic statements of what the balance of the loan is and how much of their payment is going towards principal and interest and escrow and servicing fees and all that stuff. A lot of the information that I would be required to disclose to the borrower is stuff that is already baked into my loan documentation, like the interest rate and the fees, and what the payments would be, and what the term of the loan would be. I mean, all of this stuff is baked into my land contract or deed of trust document or my note or my closing statement. Like, it's all going to be in front of that borrower at the time of closing, if not before. In terms of the periodic statements of letting that borrower know what their payments are on an ongoing basis, that kind of information would also be provided to them if I'm using a loan servicing company or if I'm using a service that sends out automatic emails notifying them of their payments and that kind of thing. So I think that this section of Regulation Z probably does apply to vacant land transactions, but at the same time, I think a lot of this information, if you're closing your transaction in a way that documents it thoroughly and requires the borrower to sign documents that disclose a lot of this information, you're probably going to take care of it through that process. This is a section of Regulation Z that I honestly didn't spend hours combing through like I did with some of the other regulations. So I'm not necessarily telling you that you should just blindly take my word for it. You may want to get your own advice from your own attorney to verify this. But as I was looking through it, that was my understanding. And just given the way that I document my loans, I'm not terribly worried about this. So that is sort of my understanding of Regulation Z. So with that said, let's move on to Regulation B. And hopefully you're still with me. I know this is really dense stuff, but the purpose of Regulation B is to ensure that borrowers are not being discriminated on the basis of their age, their race, their religion, their gender. It doesn't necessarily mean that lenders can't say no to people, but if they do say no, they can't be saying no based on the borrower's age or race or gender or nationality or anything like that. So for the typical real estate investor, again, there are some things that they would have to do if they were going to extend a loan with seller financing to a buyer. However, similar to Regulation Z, all the rules listed in this part seem to be geared towards those dwelling type properties in terms of what lenders have to do. But again, if you go here to this section and you scroll down to where it says dwelling, dwelling means a residential structure that contains 1 to 4 units, whether or not that structure is attached to real property. The term includes but is not limited to an individual condominium or cooperative unit in a mobile home or other manufactured home. So again, based on that, I do not see how Regulation B applies directly to people who are selling vacant land with seller financing. Now, with that being said, I should say that just in general, if you're ever going to say no to a loan applicant, say somebody wants to buy your property and take you up on seller financing, you can say no to them. But if you say no, you should have some kind of a verifiable, documentable reason in terms of why you're saying no. Say, like if you pulled a credit report and they have a terrible credit score, if you need a certain down payment amount and they can't do it, should not be a reason that has anything to do with these things that honestly shouldn't matter. And also, when you're advertising your property for sale, if you talk about how seller financing is available, don't say something ridiculous like, seller financing is available for white males over the age of 40. I mean, that would be just a clear violation of this. And most people are going to have no reason to do that, so it's kind of ridiculous for me to even have to say that. But just as a general practice, if you want to steer clear of any issues that may come up as a result of Regulation B, just don't say those kinds of things. And if you decline people, make sure it's a reason that has nothing to do with these issues that shouldn't be issues in the first place. For most real estate lenders out there, Regulation B would apply and it would require them to send out certain disclosures to their loan applicants. But again, when it's a vacant lot, it does not seem to apply to those particular rules, and those disclosures wouldn't be necessary for that specific type of property. So with that said, if we move on to the next regulation, Regulation X exists to protect consumers from being told that they're going to be getting one thing and then things sort of change at closing and they end up getting a different loan with a different interest rate and all that. Essentially what it requires, again, is that the borrower be giving certain information, that the lender use a certain type of settlement statement that includes certain information, just to make sure that the borrower is fully aware of all the information, kind of like over-delivering on the data, just so that there can be no mistake of what they're getting versus what they were told they were going to get. So all that's good and fine. It just requires that real estate lenders have to follow more rules and more regulations. But again, good news for land investors as far as I can see. If we go here to this section where it says coverage of RESPA, which stands for Real Estate Settlement Procedures Act. First section up here, RESPA in this part apply to federally related mortgage loans except as provided in paragraphs B and D of this section. So if we go here to paragraph B, it says exemptions, and then if we scroll down to item 4, it says vacant land. Any loan secured by vacant or unimproved property, unless within 2 years from the date of the settlement of the loan, a structure or a manufactured home will be constructed or placed on the real property using the loan proceeds. And that's a very important detail to note. If a loan for a structure or manufactured home to be placed on vacant land or unimproved property will be secured by a lien on the property, the transaction is covered by this part. So basically what that means is that if you're selling a piece of vacant land with seller financing and it stays a piece of vacant land for the duration of that loan, or at least for the first 24 months after you close it, then it should be exempted from the things that lenders have to follow under RESPA. If your borrower has plans to immediately build something or improve that property in any way, then it could very well be covered under this. So this could be another instance where it would just be smart for you to include something in your loan documentation verifying that the borrower is not planning to build anything for the life of the loan, and or if they are planning to improve the property, they will have to pay you off before they do that. And that should just sort of add that extra layer of protection that they're not going to improve that property as long as you've got a loan out there on it. So that's more good news under Regulation X. It shouldn't apply as long as it is vacant land and stays vacant land. So if we move now to the next regulation here is Regulation P. And Regulation P is all about protecting the privacy of the borrower. And in terms of whether Regulation P applies to seller finance vacant land transactions, unfortunately, there is not a straightforward black and white answer I can give you, because you sort of have to understand some of the details of your situation, and that should inform you in terms of whether or not you need to follow any rules here. So first of all, if we click on purpose and scope, the purpose of Regulation P says this part governs the treatment of non-public personal information, so that's the first key term we need to be aware of, about consumers, that's the second key term, by the financial institutions, and that's the third key term we need to think about, listed in paragraph B of this section. Now, one nice thing I was pretty happy about was that the Federal Trade Commission actually put together a really nice guide, and I'll have a link to this in the blog post, which is linked beneath this video, so go ahead and check that out if you want to read more. But basically, you need to understand, as a real estate investor who's selling vacant land, are you a financial institution? Are you selling your property to a consumer or a customer? And then what kind of information are you collecting from that borrower, and is it considered non-public personal information? So the first issue in terms of whether or not you're a financial institution, this says that the privacy rule applies to businesses that are significantly engaged in financial activities. Financial activities include things like this: lending, exchanging, transferring, investing, servicing loans, debt collecting, all this stuff. So as I read through this, I'm fairly confident in concluding that as a landowner who is selling land with seller financing, that is considered lending, and that is considered a financial activity. And in terms of whether or not I am significantly engaged in that, as this guide explains it, it says, first, is there a formal arrangement in place? Is there like an actual written agreement between the lender and the borrower? And in pretty much every case, the answer is yes. There's either a land contract or a note or a deed of trust or something like that. So there's definitely a formal arrangement in place. And then also, how often does the business engage in this financial activity? Am I somebody who's doing this like once in a blue moon, say like one time a year at the most? Or am I doing like 3 or 5 or 10 of these deals a year? And I would say it's up to each individual to figure out what camp they fall into. If you're somebody who's literally just doing this one time, it's the first time you've ever done it, and you have no plans to do it again, then you're probably not significantly engaged. If you're somebody like me who, I don't necessarily do it a ton these days, but it's something that comes up on a fairly regular basis. So I would say that yes, I am significantly engaged in this activity. So in answer to that first question, just looking at myself and what I know, I would say yes, I am a financial institution. And then, do I have consumers or do I have customers? And the difference between that is a consumer is somebody who obtains or has obtained a financial product or service from a financial institution like me that is to be used primarily for personal, family, or household purposes, or that person's legal representative. So it's kind of like an individual person who's going to be using that product personally. Not necessarily every case, but in most cases, when I sell land with seller financing, yes, I'm selling it to a consumer. And I can't answer this question for you. That's something you'll have to come to your own conclusion on based on this information. But I can't answer it for me, and that's my answer in my case. And then lastly, what information is covered? It really comes down to what kind of information are you collecting from your borrower as part of your loan application or approval process. I've done this both ways. I've had some deals where I've literally just gotten that person's first and last name and their address and phone number, whatever they told me, and that was literally all I got. And it was kind of a risky way to do it. I had no outside verification of what their legal name was. But in cases where I've bought a property for $500 and I'm selling it for $8,000 and just the down payment already pays me back completely, in those kind of cases, I may be willing to take that risk, and it's not a big deal to me. So if I'm not really collecting any sensitive information, then I'm not collecting what they call NPI, or non-public personal information. On the other hand, if I am collecting some kind of an ID statement that includes their social security number or driver's license number or a copy of their driver's license or passport or something like that, that's the kind of information that is not publicly available, and it's something that as a lender, you have a responsibility to keep that private. And I can say some lenders out there, for some purposes, will actually share this information with third parties. That's not something I've ever done, nor do I ever plan to. If for some odd reason you're planning to share that information with somebody else, then you would actually have to give that borrower the opportunity to opt out of you sharing that. It requires a certain type of disclosure form, and there's actually a template for that. And again, I will link to that template in the blog post, which is linked beneath this video, so be sure to check that out. If you are collecting this NPI information and you are not planning to share it with anybody else, say if you were only getting their social security number for the purpose of pulling a personal credit report, that's okay, and that's not considered sharing it with a third party. That's one of the allowed uses. And if that's the only reason you're doing it, just to have it for your own files and to verify that they are who they say they are, that kind of thing, then there's a different type of disclosure form that does not give them the opportunity to opt out of anything because there's nothing to opt out of. I will have a link to an example of that form in the blog post as well. And I'll just pull up this example. This is the form that you can provide if you are not sharing the information with a third party. So, for example, if I was ever collecting any non-public personal information from my borrower, this is the form I would use because I'm not planning to share that information with anybody else. And as you can see, it's a fairly straightforward form, and your form doesn't even have to look exactly like this. This is just an example that was put out there by the FTC because this checks all the boxes and meets all the requirements. And as you can see, you really just have to insert some information here and then put the words yes or no in these boxes and answer to these questions, and then include your phone number or your website, and then fill in this information too. And something you'll notice is that there's nowhere on here where the borrower has to sign anything and give it back to you. It's literally just you providing it to that borrower, and you just have to show that you gave it to them. So it's a fairly easy form to fill out. It's not complicated, but if you are collecting information to pull a personal credit report or any kind of sensitive non-public information like that, you would simply have to give this form to your borrower as part of your closing process, just so they understand what is happening. So it's really not hard. It's just another thing to be aware of if you decide to do that. And again, if you can answer no to whether you're a financial institution or you're working with a consumer, or if you're not collecting any non-public personal information, then you can just ignore this altogether. So it really just depends on the specifics of your deal and who you are and who your borrower is and what you're doing. So that's my full understanding of Regulation P. If we move on to the last one now, Regulation N. And Regulation N is all about mortgage acts and practices in your advertising. And really the idea with Regulation N is to verify that any information you are putting in your advertising, say if you have a little section in your ad saying, hey, we've got this property that's available with seller financing with an interest rate of 5% and $2,000 down payment and payments of $499 a month. If you're advertising your property with that kind of specific information, then you can't change it up when you get to closing and then sell them something different with a different interest rate and a different payment. If you go here to this section where it says prohibited representations, it just lists out everything that you can't do in your advertising, all the stuff that you can't effectively lie about. And apparently this regulation was born out of necessity because a lot of lenders were doing just that, where they would advertise certain interest rates and then give people something totally different at closing. But really what it boils down to is, if you're going to advertise certain terms in your listing saying that seller financing is available and this is exactly what you can get, then you better actually use that when you get to closing and don't change it up and do something different. And one way to avoid that, say if you want to have the flexibility to do something different when you get to closing, is to just not get all that specific in your listing. You could say something like, seller financing may be available on this property. Contact the owner for more information, and just leave it at that. And any information you discuss about the financing you're providing, especially if it's in writing, don't put it in writing and or don't say it unless you're 100% sure that that's actually what you're going to close with, because you don't want to get into any situation where somebody can prove that you said one thing and then you did something else when it came time to close it. So from my read through it, it didn't necessarily say that you're not allowed to get that specific in your listing. It's just implying that if you do get that specific, then you better follow through and don't flip the script and change the story when it comes time to close it. So essentially in a Regulation N, unlike some of the previous regulations, it doesn't necessarily give us a specific exemption for vacant land. It does talk about how the word dwelling is defined, but when it talks about what's covered, it defines a mortgage credit product to be any form of credit that is secured by real property or, emphasis on or, a dwelling, and that is offered or extended to a consumer primarily for personal, family, or household purposes. So if this just said dwelling, then I would say, well, great. because vacant land is not a dwelling, so it doesn't apply. But real property is more of a catch-all term for any type of real estate, including land. So if you have a property that's just vacant land, my interpretation is that regulation would definitely apply to that. Luckily, it's not really that difficult to comply with regulation, and it just means that you need to be aware of the fact that you shouldn't be promising all these things in your advertising that you're not ultimately going to deliver when it comes time to close. So does regulation N apply? Yes. Is it difficult to comply with? Not really. You just need to have a basic understanding of what you should and or shouldn't say based on what you plan to do in the end with your loan. So that kind of wraps up the gist of Dodd-Frank and the specific regulations that apply to vacant land transactions specifically. There's also something called the SAFE Act, which is separate from this. I'm going to put together a separate video explaining the ins and outs of that as I understand it in my own, again, non-legal opinion from my read through how it works. So keep an eye out for that too. Just let me re-emphasize the fact that I'm not an attorney. Dodd-Frank is a very complex, complicated ball of legislation. It took me a lot of mental energy just to read through it and understand it. So I don't want to by any means convey that what I'm saying here is the ultimate final rule and truth on how vacant land transactions should be handled. I think there's variations in every deal. And again, since I'm not an attorney, there could very well be things that I'm just missing here. But based on what I read from at least a dozen other articles and blog posts out there, and based on what I read directly in these regulations, I'm fairly confident in the conclusions I came to. And this is how I'm going to be treating these regulations in my own seller finance deals. So that may or may not apply to you, but hopefully just through that overview we went through, if you're still even watching this, I know that's a lot of left brain stuff I just covered. But if you're somebody who's selling vacant land with seller financing, I hope that gives you at least a little bit of clarity in terms of whether Dodd-Frank applies to you, and if so, which specific aspects you should be paying attention to. So again, I'm going to have a very detailed blog post linked beneath this video, which really lays out all of my research and thoughts in written form. I think that could be helpful if you really want to dig deeper and find out how I came to these conclusions. And by all means, if you're watching this and if you're a lawyer and or if you're a real estate investor who has experience with Dodd-Frank as it relates to seller finance, vacant land transactions, and if you think I'm flat out wrong about any of this stuff, or if you think I'm just missing something, I welcome your feedback. Please feel free to leave a comment below. Let me know what you think. If anybody brings up an issue that I think is significant enough, I'd be happy to update this video and or blog post if I think it really applies. So that's that. Hopefully you found that helpful on some level, and thanks for watching.